According to your call for the senator judges, if any, to make an input on this question before you issue your ruling. My first comment is this. Under the complaint, Article 7, the defendant is charged with betraying the public trust, and I'm reading now, quote, through his partiality in granting a TRO in favor of President and Mrs. and her husband, Jose Miguel Arroyo, etc. So the question under Article 7 simply is, did the Chief Justice show any partiality when the temporary restraining order was granted, not by the Chief Justice alone, but by his colleagues in the Supreme Court? That is the question today before us. Now, I have a copy of the internal rules of the Supreme Court. Rule 12 is entitled Voting Requirements and is self-explanatory. And Rule 13 is entitled Decision-Making Process. It appears, from what the witness has said so far, that she has never personally participated in either counting the votes or in the decision-making process of the Supreme Court. In fact, she has said she has no personal knowledge. She has admitted that. Now, according to the Rules of Court, Rule 130 on Rules of Admissibility, Section 36, testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his own personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. If she was absent, how could she have personal knowledge? What? She is in effect, therefore, offering to us her opinion. But I've already said several times in this session hall that no opinion is allowed by the rules of evidence unless the expert has first been qualified as an expert witness. She has not been so qualified. She was not present when these so-called irregularities or discrepancies were taking place. So how can she be a witness on this instance, on the particular point of fact of whether the Chief Justice took an active role in issuing the TRO all by himself, when, according to the witness herself, according to the internal rules of the Supreme Court, which are available to lawyers like us, no one justice is allowed to issue a TRO all by himself. So, defense is correct in invoking the hearsay rule. There are exceptions to the hearsay rule. There are 1 to 11 exceptions. Which of these exceptions is the prosecution trying to ground its position on? The general rule of evidence is no hearsay. Only eyewitness can testify except 1 to 11. Under what exception is being quoted? Why are we splitting hairs? It's very, very clear. A witness can only testify as to what he perceived himself, except that there are 11 of these exceptions, and none of them is being cited by the prosecution panel. So in effect, what we have been hearing is a series of opinions extrapolated or explained to us by the witness. But we have already seen that a witness is not allowed to express an opinion unless she has been qualified as an expert witness. And there are rules for qualifying her. Let me quote only one case, just one case, decided only this month, February 1, 2012, the case of Malayan Insurance Company v. Reyes. Here is the Supreme Court. Concomitantly, a witness may not testify on matters which he or she merely learned from others, either because said witness was told or read or heard those matters. Such testimony is considered hearsay and may not be received as proof of the truth of what the witness has learned. This is known as the hearsay rule. Maybe just one other case, Estrada v. Desierto, 2001. But notice that what I cited was a case issued only this month by the Supreme Court, educating all of us in the law profession and in the general public. Estrada versus Desierto. There are 3 reasons for excluding hearsay evidence. 1, absence of cross-examination. 2, absence of the manner evidence. And 3, absence of the oath. Now, we are talking, the witness insists that her opinions are well-grounded on the dissenting opinion of a singular justice of the Supreme Court. So we are now faced with the issue of what is the weight of a dissenting opinion. The Supreme Court itself said in the 2008 case concerning Mr. Amado Makasait, quote, the Supreme Court stated that elementary decision-making teaches that we cite the majority opinion as precedent, not lonely dissenting opinions. Another case, 2006, Yes I.S. v. Amir-Hazsann. It is the majority opinion and not the dissenting opinion that is the controlling jurisprudence. These are accepted facts in law school. Why do we have to debate these topics? We can safely take them for granted. So to return to Article 7, our quest here is factual in nature. Was the Chief Justice personally and individually responsible for what are perceived deficiencies or irregularities in the issuance of the TRO? The TRO is a subject matter, and the target of this particular Article 7 is the Chief Justice, the respondent. The issue therefore is, can one judge be held liable for the decision of a collegial body? Here is the Supreme Court speaking in an administrative case filed by an individual against certain justices of the Supreme Court, and here is what the Supreme Court said. Although the Chief Justice is primus inter pares, first among equals, he cannot legally decide a case on his own because of the court's nature as a collegial body. Neither can the Chief Justice by himself overturn the decision of the court, whether by division or the en banc, whether by division or by the entire Supreme Court. And here is an excerpt from the book, Judicial Opinion Writing by Joyce George, in its 4th edition, as early as 1993. In writing an opinion, the writing judge is involved in a joint venture. The end product is not his opinion alone, but rather that of all the members of the panel who form the majority. So I return to the issue at hand. The issue at hand is simply this. Is the witness qualified under the rules of court to testify on this particular matter? Answer no. She said no herself. She said, I'm not a member of the court. I've not been there. I was not present. I was just reading the opinion, the dissenting opinion of one of the dissenting justices. That's what she said. So she's not testifying according to her own personal knowledge. That falls under the hearsay rule. As I said, I admit that there are 11 exceptions to the hearsay rule. Therefore, prosecutor has the burden of showing that at least one of the 11 exceptions to the hearsay rule applies. Otherwise, there's no point belaboring this issue. We can move on. Let's move on, counsel. Thank you, Mr. President.
Thank you.
Mr. President, may I react to the distinguished lady senator and now international jurist?
Proceed.
Mr. President, point of order. He will engage in a colloquy with me, a judge. The judge has spoken. Now the judge is taking time to deliberate on what she has just told the court. I don't think this is proper.
Counsel,
you should debate among yourselves. You do not debate with a judge.
Yeah, counsel, I'm sorry. A member of the court objects to any further discussion. So
Yes, sir.
I will make